Thank you for tuning in to Exeter TV. Exeter TV is the town's public and government access channels, available on Comcast Channels 6 and 22. Channel 6 is your channel. If you have an idea for a program, want to host your own talk show, or submit a film, we're here to get your content on television. On Channel 22, we bring you live and replay coverage of government meetings and other town updates. A third channel, Blue Hawk Media, is operated by SAU 16 and can be found on Channel 8, with all your school sports, events, and meetings. You can watch Exeter TV online at exeternh.tv, Apple TV, and on Roku. Find us on social media for extra content. Subscribe to our YouTube channel and hit the bell to get notified about live streams and new content. Tune in to our platforms every other Friday to watch the Exeter Biweekly Report, with recaps of recent events, updates from town departments, and messages from nonprofits in your area. If you head to our website, exeternh.tv, we invite you to sign up to our newsletter to receive monthly updates about new content, upcoming meetings, and more. We'd like to thank you for taking the time to watch Exeter TV and hope that you tune in to our other content as well.
Welcome to the Zoning Board of Adjustments meeting for May 20th, 2025. I'm Estrelsa Murphy, the chair. I'll introduce the board. On my far right is Laura Montagno, Laura Davies, and Teresa Page. Then to my far left is Mark Lemus, Kevin Baum, and Bob Pryor. Tonight, we have one piece of new business. It is the application of the Pickpocket Abutters Group for an appeal from an administrative decision made by the Planning Board on February 13th, 2025 for the approval of the demolition of an existing administrative building and the proposed construction of a new supportive living health center, along with associated site improvements on the property located at 5 White Oak Drive, Planning Board Case 24-16. The subject property is located in the R1 Low-Density Residential Zoning District, as identified on tax map parcel number 97-23, ZBA Case 25-2.
Madam Chair, at this point, I'll recuse myself.
Yes, you may.
Thank you.
Likewise, Madam Chair, at this point, I'll recuse myself. Just going to slide my chair up. Just gonna slide.
There's no place else to go.
There's no.
So unlike last month, this month we do have 5 full members. You can't hear, can you? No. Yeah, the mics are for the recording, not for the room. So we'll try to speak up so you can hear.
Use the microphone, please. It works. Speak closer to the microphone.
Bring it into you.
There you go.
Bring it in closer.
Try that.
How's that?
There you go. You will hear it now.
Okay. So we have a full board for you this month.
We do. Thank you very much.
Do we need an alternate to vote? No.
Yeah.
So you are the alternate. Okay. I'm there. Thank you, sir. The floor is
All set.
yours.
5 voting members. Lovely. Thank you. Good evening, Madam Chair, members of the board. I'm Robert Pryor of 16 Pickpocket Road. I'm an abutter to Riverwoods, and as you just saw, I'm also a member of the Exeter Zoning Board of Adjustment. I'm speaking this evening as a member of the group of over 100 residents of Exeter who are appealing the decision of the Exeter Planning Board to approve the Riverwoods Combined Health Center without their first having applied to the Zoning Board for a special exception. Our attorney, Brian Bouchard, to my left, will be presenting our appeal, but I would like to begin with a brief overview of 5 key points. The first is complexity. This is indeed a complex appeal, the specifics of which Attorney Bouchard will present in detail. In the hundreds of applications and appeals that I have heard in my 17 years on the ZBA, I have never been presented with an appeal of a planning board decision. Attorney Bouchard will explain the rationale for this. I've also never seen a project of this magnitude, a project of any magnitude, frankly, be allowed to move forward in clear violation of the Exeter zoning ordinance. Process. This appeal is all about process. We are not here this evening, and I'm ad-libbing at this point, we are not here this evening to talk about the merits of building the building. We're talking about the process of the approval for the building. It is about honoring the zoning process established by the voters of Exeter and governed by the laws of the state of New Hampshire. Every square inch of Riverwoods, their 3 campuses, plus multiple private homes and lots that they have purchased and merged, is in the R1 low-density residential zoning district, where elderly congregate healthcare facilities are permitted only by special exception. Let me emphasize, Riverwoods has never applied for a special exception for their proposed merged healthcare facility. Scale. Exeter Hospital has 100 beds. The proposed combined Riverwoods healthcare facility will have 126 beds. And according to the site plan that Riverwoods presented to the Planning Board, the building will be in excess of 173,000 square feet in size. Incidentally, the average Walmart supercenter is 179,000 square feet. It will have well over 100 parking spaces, 70 employees, and cost approximately $150 million to build. It is impossible to believe that such a structure could be built in the R1 low-density residential zone without a special exception being applied for and granted. It is in the best interest of the town of Exeter, the best interest of the Zoning Board of Adjustment, the best interest of the aggrieved persons here before you this evening, and in the best interest of Riverwoods itself to get this process right. and it is not right the way it is. Only you, by finding in our favor, can make it right. A bit more on the appellant group. It is noteworthy that the group is composed of over 100 individuals from 3 distinct groups, all of whom are aggrieved by this process. As you would expect, many abutters have signed on to this appeal. In addition, there are over 60 residents of Riverwoods who have been bold enough to sign on to this appeal, as well as a large group of neighbors from our area of Exeter. Finally, a little bit on the future. Riverwoods has expanded many times over the years. First the woods, then the ridge, then the boulders, then an administration building, and now a massive combined healthcare facility. I referred earlier to several private homes that Riverwoods has purchased. In addition to the multiple properties that are already merged with their 3 campuses, they also own several other properties that abut or are very close to their campus, including a parcel on Kingston Road that abuts Boulderbrook condominiums. Riverwoods clearly plans further expansion on property they already own. Unless you make them adhere to the zoning ordinance now, what is to stop them from using this as a precedent for undertaking further expansion in the R1 zone without a special exception? By ignoring this issue now, the town is giving Riverwoods a license to expand without zoning oversight from this board. Allowing this project without explicit approval from the ZBA will set a precedent not just for future Riverwoods expansion, but for Exeter and perhaps even the state. This precedent could and likely will forever change how zoning requests are managed, and will certainly change how we envision the future of Exeter, especially our end of Exeter. We would ask that you find in favor of the applicants and appellants and require Riverwoods to apply to the ZBA for a special exception. Thank you. Mr. Bouchard.
Just one point of order, actually, if you don't mind. One question I had, Madam Chair, is, in my mind, there's...
Speak up, please. Speak up.
Point of order that there are 2 issues in my mind tonight. One is the one of timeliness and jurisdiction, and the other is the sort of merits of the special exception. Do we want to discuss those or ask the applicant to discuss those or address them separately, jurisdiction up front, or go through the whole presentation on both issues, and obviously allow public comment on both issues before going forward?
We could probably start with jurisdiction, move through that, and then see where we go from there. Does that work?
I think that makes sense. So allow the applicant to present, allow public comment on that issue, and then we can go from there.
Yes.
You ready to proceed?
We are ready for
Yes,
you to
thank
proceed.
Madam Chair, members of the board, good evening. Can everyone hear me okay? No. No? Great. How about now? Now? All right, well, I'll do the best I
I don't
can.
think it broadcasts.
It
Sorry.
doesn't. It's for the audio visual in the back. They pick it up.
We'll do the best I can. I don't want to feel like I'm yelling at you.
Portable mic? Is that-
This is the portable mic.
He has
I
one.
don't know that it makes any
Okay.
difference.
Let's proceed. My name is Brian Bouchard. I am an attorney at Sheehan Finney Bass and Green in Portsmouth, New Hampshire, and I represent approximately 112 abutters and residents with respect to this appeal. And contrary to the position that was taken in the document submitted by Riverwoods, everyone whom I represent has standing to file this appeal. Abutters are afforded automatic standing, but under the Weeks case and its progeny, there is a broader understanding of standing. If the individuals have been participating in this process, which we have been, and if the individuals are going to be substantially affected by the development. As Bob noted at the beginning of his presentation, I want to make clear, categorically clear, that the purpose of this appeal is not to stop a development. That is not why I am here. I am here to ensure that the processes that exist in this town, which I am also a resident of, are followed, and that its ordinances are upheld and cannot be blithely cast aside. To that end, I am not here to comment on whether or not Riverwoods should or should not receive a special exception application. I have made no opinion about that, and I think Riverwoods is entitled to submit a special exception application without anyone having judged whether or not it should be granted. Now, as Attorney Baum correctly noted, I'm sorry, is it Baum? Did I have it right?
Yes.
Okay. As Attorney Baum correctly noted, there are two issues before the board tonight. One is a seemingly esoteric issue of jurisdiction that maybe only the attorneys care about or find interesting. And the other one is a more straightforward issue of the merits. And I'm going to take each in turn, but I will stop after jurisdiction so the board can vote on that. This board has jurisdiction over this matter pursuant to RSA 676-5. It has jurisdiction over this matter because we are appealing a decision of the ZBA that made the determination, both expressly and impliedly in approving the site plan application, that the Riverwoods expanded healthcare facility does not require a special exception. I am not here appealing Mr. Eastman's letter of March 5th, 2024, either substantively or procedurally. I'm not appealing it substantively, and we are not appealing it substantively, because the letter declared that this healthcare facility, the expanded healthcare center, doesn't require a use variance. The letter makes no mention, however, as to whether or not a special exception is or is not required. There's no indication in the letter that whether or not a special exception is required was considered. So this isn't a substantive appeal of that issue. It also is not a procedural appeal of that letter, because the appeal emanates directly from the planning board and not from Mr. Eastman's letter. And there is a case that we cited in our materials from the New Hampshire Supreme Court that is quite instructive on this issue. And it is the Accurate case in the town of Derry. And there, an abutter, after the planning board granted site plan approval, filed an appeal with the ZBA, stylized as an appeal from a code enforcement officer that had been made 11 months earlier. The ZBA, on its own volition, converted that appeal to an appeal from the planning board decision as to whether or not the proposed project was compliant with the ordinance. And this is where it gets interesting. The ZBA, in making that conversion, noted that it didn't have jurisdiction to consider the code enforcement officer's opinion or a decision from 11 months earlier, because that issue would have been time barred. But it did, relevant to here, but it did, relevant to this issue, say that it did have jurisdiction to consider the planning board's determination as to whether or not the project required any type of application in the city, or, excuse me, in the town, or whether or not the project was compliant with the ordinance. And that was expressly discussed in the opinion. And that is what the Supreme Court held, that when you have a planning board process that considers whether or not an application is compliant, that creates independent grounds for appeal. Now, as Attorney Baum probably knows, sorry to pick on you, you never really find a case that's on all fours with the issue you want. You know, sometimes there are some elemental differences that make it distinguishable or not. The Accurate case, as applied here, and comparing the Accurate case to this case using a legal term, is pretty darn close in terms of its factual trajectory, its procedural trajectory, what the planning board decision said, and what the Supreme Court ultimately held. Here too, the Exeter's site plan review regulations prohibit the planning board from granting site plan review, from granting site plan approval if the project doesn't comply with the ordinance. And that is an affirmative obligation that the planning board must take up and must make. There is nothing in the site plan review regulations that allows the planning board to say, well, this may have already been decided by Mr. Eastman and that's not appealable anymore, and so therefore it's compliant. No, what 8.3 requires is that the planning board make an affirmative determination that this is compliant with the ordinance. It cannot vote a project through if it is uncompliant or incompliant. And here, the planning board considered whether a special exception was required in two meetings, first in January and then in February. And in the meeting in February, it considered 6 different iterations of a motion to send this project to this board to determine whether or not a special exception would be required. And it considered whether it could impose review of this board as a condition of approval for site plan. That vote was ultimately denied, and that creates the basis for an appeal. Now, Riverwoods in its opposition contends that this appeal is untimely because the planning board merely accepted the binding, supposedly unappealable decision of the code enforcement officer here, Mr. Eastman. Well, that's inaccurate for 5 reasons. The first is that's not what the planning board voted on. There is no motion to accept the determination of Mr. Eastman. And that's not the motion that they considered. The motion that they considered and voted on was to whether Riverwoods must go before the ZBA relative to the needs of a special exception. That's what they voted on. Second, Riverwoods' argument doesn't pass muster under the accurate case. In fact, in its opposition, Riverwoods doesn't deal with the accurate case at all, which, as I've noted, is quite similar to this case in that it involves a code enforcement officer decision made earlier in the process, a planning board decision, and then an appeal of the planning board decision where the Supreme Court of our state said that appeal, the appeal from the planning board to the ZBA, is a question that is properly before a zoning board. Riverwood's position ignores the site plan regulations of this town, particularly 8.3, which I've already gone through. Fourth, agreeing to accept Mr. Eastman's position, if that's what the the planning board in fact did, which it didn't, is itself a decision. And finally, I think Riverwood's position is a misreading of the March 5th, 2024 letter from Mr. Eastman, because that letter doesn't mention a process or a review of whether or not a special exception is required. Now, Riverwoods makes the position that, well, when you go and you ask a code enforcement officer supposedly what you need, it would be abnormal for the code enforcement officer to say what you don't need. But that's almost exactly what happened here, so we know. Mr. Eastman made a determination as to what was not needed. And what he determined what was not needed was a use variance. We also don't know what Riverwoods actually asked Mr. Eastman to decide. If Riverwoods only asked Mr. Eastman to decide whether or not it needs a use variance, it would be perfectly normal for Mr. Eastman to issue a letter saying you do not need a use variance anymore because you've merged the lots. And finally, to round out this issue on jurisdiction, there's a case that I found, as sometimes is the case, at 4 o'clock while I was leaving the office. And it's 22 Lenox Ave versus the town of Derry. And I have copies if anyone would like it. It's an unpublished opinion from the New Hampshire Supreme Court, so it's not entitled to any type of precedential value. But I will say it is instructive as to this issue. And in that case, pull up my notes about it. That case had the following facts. In May of 2013, a code enforcement officer issued a decision saying that a project was permitted in the medium density zone in the town of Derry. On May 15th of 2013, the planning board rejected a site plan application in large part because the planning board disagreed with the code enforcement officer, and the planning board decided that this project actually was not compliant. On June 14th, 2013, 30 days later, the developer appealed the planning board's decision to the Superior Court, did not go to the ZBA first. And the town, as you might expect, filed a motion to dismiss, saying that the project developer failed to exhaust his administrative remedies. And in response to that motion to dismiss and opposing the motion to dismiss, the developer argued that, well, the exhaustion issue is moot because nobody appealed the code enforcement officer's decision from earlier in May. Therefore, the decision is binding not only on the planning board, but on the ZBA, such that there was no requirement to go to the ZBA because the ZBA was powerless to do anything about it. And the court rejected that argument, saying that no, it is emphatically the province of this board and all ZBAs to consider those decisions of code enforcement officers and of ZBA and of planning boards when they make a determination that involves the construction, application, or interpretation of the zoning ordinance. So if we flip the script on this case, I know this is a little bit of a hypothetical, but every case at the Supreme Court's a hypothetical. If it was the opposite, that the planning board decided that Mr. Eastman had erred and that this project does require a special exception, and Riverwoods appealed that to this board, Riverwoods could not argue that Mr. Eastman's decision was somehow binding on this board because nobody had appealed a private letter from March 5th, 2024. In fact, the argument would be that this board then has the obligation to determine whether or not the planning board's construction and interpretation of the zoning ordinance was correct. This case before you is just the contrapositive of that. There's nothing different. Riverwoods is making arguments here about jurisdiction that the Supreme Court has already rejected in the Accurate case. And it is the closest case that I have found from the New Hampshire Supreme Court about this issue. And that case holds unequivocally that this board has jurisdiction to consider this. With that, I'll entertain any questions that this board has.
Less of a question, Attorney Bouchard, but I would like you to speak. I mean, you've indicated that Doug Eastman's letter, does not address whether a special exception is required, but it does state that the proposed use is now permitted as of right.
I'm not appealing Mr. Eastman's letter. So I'll answer your question though.
Well, you've spoken to the letter. So.
I've spoken to the letter to the point that I did want to counter what Riverwoods is saying. But I want to make clear, I am not appealing Mr. Eastman's letter, procedurally or substantively. Now, to your question, yes, I agree with you that Mr. Eastman's letter does say that. But in the context of that paragraph, it is whether or not a use variance is still required now that the properties have merged. Reading that paragraph within its entire context, it is a decision about a use variance, not a decision writ large about the ordinance. There is nothing in that letter to indicate that this was ever even considered. And it is not an opinion of an administrative officer if it isn't considered.
Understood.
Could you just say the last piece again?
It is not an opinion of an administrative officer if the issue is not actually being considered or addressed in the letter.
Okay.
There is nothing in that letter to say that this was ever considered at all, and in part because we don't know what Riverwoods even asked Mr. Eastman to entertain. But I'm not appealing Mr. Eastman's letter. We are appealing the decision of the planning board as to whether or not this project is compliant with the zoning ordinance and whether or not this project was something that needed to come before this board first for a special exception. That's the issue we're appealing. That's the interpretation and construction of the zoning ordinance.
do have one question about
No,
the
please.
accurate case. In that fact pattern, the code enforcement officer had given a letter of opinion. Is that distinguishable from this situation where it's styled as a decision?
No, they're not a decision. In the accurate title case, the code enforcement officer gave an opinion that was actually on all fours with the issue, gave an opinion that the project was compliant, and that was during a technical review committee meeting approximately 11 months before the planning board picked this up. And then the planning board picked this up and made its own determination. And then an abutter appealed that issue to the ZBA saying, and the appeal was actually titled, an appeal of the code enforcement officer's decision. The ZBA, in its discretion, converted that to an appeal from the planning board officer. So it's not different. In fact, the accurate title case is even more attenuated because in that case, the opinion of the code enforcement officer was directly as to the issue. And in this one, Mr. Eastman's letter is far more attenuated, talking about whether or not there still needs to be a use variance.
Thank you.
We have any, something else?
No, I don't have any more questions. I would recommend we take public comment on the jurisdiction issue
Okay.
before diving any,
Further,
going
yeah.
any further.
It's a lot to absorb.
Yeah.
Do you also plan on making a vote on the jurisdiction issue? A separate vote or decision? I'm curious why you're separating public comment into two sections.
Well, because we can't make a decision on the special, the merits of the special, or whether a special exception is needed without getting to jurisdiction in the first place. So yes, I mean, we haven't decided that, but my thinking at least is that there would be a vote taken on that issue, on the jurisdiction issue, before moving forward.
Do we typically take public comments on jurisdiction questions?
That's an interesting question.
I'm not aware of that, so I'm just asking.
Yeah, well, we.
I'm just trying to go with the normal
Yeah,
steps.
this is an unusual case. I think in this case, in all fairness to the public, I think it's, I think it's worthwhile taking it. And that would include comments from Riverwoods as well. But, I think that's the threshold issue here. So I would hate to go forward without hearing, from everyone on this issue. But I guess we can make that decision. We also,
It doesn't seem like it's our typical practice to take public comment on jurisdiction issues, but that's just my experience.
Yeah, typically it's not argued. Yeah, fair. I mean, I think typically it hasn't been argued before us. It's been something that has come up and we've determined we don't have jurisdiction without any comment, including, I think, usually discussion with the applicant.
Okay.
But I guess we don't, we can discuss that further. If we don't, I'm happy to have that discussion.
Do we need to open public session to let Riverwoods have their,
I mean, I think in all
Say.
fairness that we probably should hear. But, we also do have counsel in the audience, here tonight, so we can always adjourn and confer with counsel.
I don't know. I'm not an attorney, so
why don't
this is
we-
a little out of my depth for.
yeah, I think why don't we go into non-public session
Sure.
to work this out and then come back at it? Is that,
I guess, sure.
we don't have to, I'm putting out options.
Yeah. Yeah, why don't, I'll move that we go into, we adjourn non-public to talk to counsel, to
That makes more
about the
sense to me
procedural-
than opening it up to
procedural
public
questions.
session.
Okay,
Thank you.
so we're going to go to non-public session.
Do we
Little
need
bit.
to, did you make a motion, Kevin?
I made a motion.
I'll second Kevin's motion to go into
Okay.
private session.
All in favor?
Aye.
Aye.
We'll be going to non-public session. We would like to move to public session, which will start off with us hearing from Riverwoods.
Thank you, Madam Chair. For the record, I am Chris Bolt of Donahue, Tucker, Chandela.
Do we want him to stand up at the mic for the recording?
My seat too, Chris, I don't mind.
Oh,
Not a,
Either- as
either way,
long as-
I bellow
yeah.
with the best of them.
Well, but you, no matter how loud you bellow, you still need to speak into the mic just so it picks it up.
Fair enough.
And I would also just add, both for Riverwoods and for any other members of the public, we bifurcated this, so this
Right.
is. I just trust you understand, but we're speaking to jurisdiction only at this point.
Certainly. Happy to address the jurisdictional issue. In short, you do not have it. I take, I should say it politely, I believe Attorney Bouchard is wrong on the interpretation of the accurate case. The key fact there that he did not mention is that the town's ordinance expressly required a written opinion, and there was none in that case. That meant that the trigger event had not occurred in the accurate case. It does have this anomaly of it is brought forward as one thing and the ZBA transformed it. That is not in your case here. So I would say accurate is not on all fours with the facts before you. I do say that we have an express opinion, express decision by Mr. Eastman back in March of '24. That was then followed by an appeal of Mr. Pryor that was before this board, and you found that at that time it was too late then. What you have also in the minutes that my colleague Sharon Cuddy Summers provided you in her April letter are minutes from the March 24 ZBA meeting and the April 24 ZBA meeting. In that first meeting, it's expressly referenced to have Mr. Eastman's opinion, that it was as a matter of right. Those first minutes also reflect that Mr. Pryor was there and made comments, that the Goodenoughs were there and made comments, and Mr. Theodore was there and made comments. Those are three of the actual abutters to the project. Those are people who would have had standing to bring the challenge to this board within 30 days of Mr. Eastman's decision, and they did not. We have statutes for a reason. The issue of abutter status has changed, as you know. September 1st of '24, a new statute came into play that removed the old standard that was under the Weeks case that Mr. Bouchard references. It now creates abutters in a more limited class, anybody across the street or stream, plus 50 feet on either side of the extension of the property lines. That is the class of abutters. The legislature, in whatever wisdom they were exercising underneath the Golden Dome in Concord, said we're no longer going to have the party aggrieved type of standard. So the 100 or 112 or how many ever it is in a given day is actually limited down to the 10 or so that Attorney Summers lists in Exhibit 6 to her letter before you. What we have is the rights of a property owner who has gone through the system, who did get a decision from Mr. Eastman, and that was known to the parties that could have changed, could have brought an appeal to this board at the time. And instead, they sat and they waited to see what the planning board would do. And the planning board approved the project. Now, one of the things that Mr. Bouchard learned at 4 o'clock, I learned yesterday, provided a copy to Attorney Bouchard and to Attorney Lefebvre, is a decision for one of my towns, Thornton, up in the north, that Judge Kloss, the land use judge to which this issue would go, made a decision, and if I may approach, Madam Chair, this is the Andrew v. Thornton case that actually is pretty much on all fours with what we have here. And that was a situation where an abutter did not like what was going on a lot next door. The gentleman was doing a construction yard, and the individual thought that wasn't allowed and filed a complaint with the town. The town selectmen in that town are the equivalent of Mr. Eastman. They issue the building permits. They are the code enforcement officer. And in that case, the select board said, we will investigate, we'll get back to you. They investigated. They had site walks. They went out and looked at things. And they came back and made a determination that no, there was no violation of the zoning ordinance here. They wrote a letter to the abutter. The abutter did not appeal. The applicant, the construction contractor, said he wanted to get a minor site plan approval just so everything was on record. Not me. And he went, and the planning board, in their determination, said, we have the selectmen's decision. We are granting the site plan application. The abutter appealed that decision to the Superior Court, much like we have here. They are complaining of the time. And they sued both the planning board and the ZBA. The issue was the appeal timely? And the court found that the ZBA properly held it did not have jurisdiction, and that there was no interpretation of the zoning ordinance by the planning board by relying on the underlying decision. Accordingly, this is a case, the Andrews case, I believe, supports your determination that you do not have jurisdiction. The materials that were provided by Attorney Summers give you the detailed history of the Riverwoods project over the course of time. But it is important to realize that we specifically went through the merger process after having the variance denied as a means of accommodating what we thought was the proper interpretation of the zoning ordinance. Mr. Eastman issued his letter in March. There is an appeal by Mr. Pryor going along the time frame. It is one where if there was to be a challenge to Mr. Eastman's letter, it should have been done in April of '24, not in '25. I'm happy to answer any questions you may have. I also do disagree that the non-binding case that was given to you today, it is much like mine. It's not a, it's there to show you what the court who is going to hear this case has just done. I believe the 22, whatever it was, Lyman Street, Lennox Street, is based on prior law that was changed since the time of this decision in 2015. I think it also has been overruled by implication by the Bartlett v. Manchester case, which basically says you don't have to bring an appeal of administrative decision if you're coming before the board to get a variance or special exception, because inherent in each is, do you need the relief that is being sought? Happy to answer any questions you may have.
I have a question on I want to understand your statement on standing. Are you indicating that the applicants here do not have standing, or only that they have fewer members of the group have standing than they?
Fewer members of the group would have standing,
but
under the current case, under the current statute.
But you're not questioning whether there is standing to bring the appeal?
No, I'm saying you don't have jurisdiction to handle the appeal that was brought to you, but you don't have a group of 112 people. You have the 10 or 12, how many are ever listed on Attorney Summer Exhibit 6.
Okay. Thank you. Just wanted to make sure I understood the point.
I was a little lost when you were talking about when the abutters, Mr. Pryor, and a couple of other people had the opportunity to speak. At what point in time and at what
Sure.
point in the process?
If you
was
look
that?
at Attorney Summers' May 8th letter to you, it attaches certain minutes and then also certain transcripts of the tape of those hearings. And the first set of minutes is from March 19th of '24.
So many documents. I cannot put my hands on that letter.
Laura, I believe that is what he's.
The May 8th of '25 letter from Attorney Summers attached a number of minutes, two sets of minutes and two sets of transcript. And if you look, the first set of minutes is labeled March 19th, 7 p.m. That is March 19th of '24. And if you look 5 pages in, I'm not sure if you have.
I think it was on page 4.
Is this what you're talking about?
No, this one. In the minutes,
Oh, in the minutes.
Sorry, pointed in the wrong direction.
not a word. First page, second page has a highlight. Third page, fourth page is all of your internal discussions. Fifth page, sixth page, seventh is all the discussions. It's page 8 at the bottom. I think one more page.
Not numbered.
Here we go. Bob Pryor makes comments. And then next page over, bottom of the page, Susan Goodenough makes some comments. Next page, Glenn Theodore makes some comments.
So
And the
this,
same page, Bill Goodenough makes some comments.
so this is in March, when the discussion was about a variance. That's what I was trying to clarify.
Right, but it brings up the March 5th letter from Mr. Eastman. So they were put on notice, and our standard is, did you know or should have known? And
Far from clear to me, as a member of this board, that there was that
definitely-
administrative
that's your
decision.
copy. Do you want it back then?
Oh, yeah, sorry.
I gave you a whole pile. We'll figure it out.
Oh, was this yours too?
Probably.
Sorry.
Okay, sorry. Okay.
Anybody else have any questions? You look like you're thinking, Teresa. Okay.
I don't.
Okay.
no.
You good, Mark?
Yeah, I don't have any questions.
Okay, so with the number of people here, we would like it to open up to public session now, keeping in mind this is only about jurisdiction. not about merits of the case. So if you have comments about us being able to hear this case, you can come up to the mic now. No one? Okay, so how would you care to proceed?
Well, I think,
Oh,
I
yeah,
think
yeah.
we would typically let the applicant
you have your-
provide.
Okay, let me just collect my thoughts here.
I thought we were in public session.
We are.
We are.
I think that was in public session. I think opening up, the intent was
We
to
were in
open it
public
up
session,
to members, other members of the public who wish to speak to the jurisdiction issue.
Okay. So I don't think it's material, but the amendment to RSA 672-3 about the abutter standard broadened who can be an abutter. It didn't abrogate the Weeks case. What it abrogated.
Can you give,
What it abrogated was this case, I think it was from Seabrook, where the Supreme Court said that somebody diagonally across the street was not entitled to, or wasn't considered an abutter. But this, we have standing, and anyway, the RSA 674-33 says anyone aggrieved. So we have people.
and in my mind, just for the record, I mean, I don't think there's been any statement that the applicant doesn't have standing, so.
I disagree with Attorney Bolt's, I guess, reading of accurate, that there was this critical issue as to written in there. In fact, when I read the case, and this is directly from the case on star 111, star 110 to 111, to the extent that O'Connor, the petitioner, challenged the code enforcement officer's determination regarding the proposed use of the property, the ZBA denied the appeal based upon lack of jurisdiction because it deemed the appeal untimely, not because it was written or unwritten. Oops. This is in the papers. Regarding the Andrews case that I received at 7, this is a factual specific case. And it's factually specific for a couple of reasons. First, in this Andrews case, if I can find my notes about it, the Select Board made its administrative determination in September of 2023. Then, the developer filed a site plan application, and in May of 2024, in determining whether to accept the application, the planning board made a decision as to whether or not it was compliant with the zoning ordinance, and in part of making that decision, affirmatively decided to rely on the decision of the code enforcement officer. The planning board then considered the application on its merits in July of 2024, and the appeal followed afterwards. That's not what happened in this case, because in this case, the planning board accepted the application but didn't make any concrete conversations or didn't have any conversations about compliance with the ordinance upon accepting it, and didn't have conversations about whether or not it was compliant with the ordinance until January and February, and didn't make a final determination until February. Additionally, there's a factual distinguishing here. In the Andrews case, the board, it's a little opaque from the opinion, seems to have made an affirmative decision to rely on the decision of the code enforcement officer, such that the ZBA said in the opinion, the planning board did not make a decision as to the construction of the ordinance, but instead relied exclusively on the administrative decision made by the select board, or the code enforcement officer, the select board. Here, the Exeter ZBA is considering on page 4, line 135 of the minutes, whether or not to reopen the entire application process so they can hear from Mr. Eastman. Right? Far from relying on Mr. Eastman's alleged interpretation, our board is considering whether it needs to reopen everything so it can hear from him. And they didn't do that.
But but they do specifically, and ultimately it was a motion that didn't pass, they did specifically discuss whether to condition the motion on requiring a special exception.
No, I agree, and that's what creates the basis for this appeal, is that the planning board does decide and does discuss whether or not a special exception is required, and the motion they make, there's 6 iterations of them, but the motion that is ultimately voted on is whether or not Riverwoods shall have to go to this board to determine whether a special exception is necessary. But the Andrews case is different, and that the Andrews case, apparently, there is an express vote to accept the determination of the select board, which is materially absent from the planning board minutes here. In fact, the planning board minutes here, while there are conversations about Mr. Eastman's opinion and what he may have said to the TRC, there are also provisions in the minutes where the board is asking whether it needs to reopen everything so that it can hear from Mr. Eastman, which is a far cry from simply accepting his decision.
Well, yeah, I mean, I guess I don't know that I mean, they're looking at page 4, line 51, Mr. Gruder noted the building inspector said they don't need it.
Yep. Page 4, 135, Ms. Martell questioned whether it could reopen the request such that it could be reopened to request such a letter from Mr. Eastman as to whether or not it's compliant. It puts this case on entirely different footing. And also in the Andrews case, there is no treatment of the accurate decision, which, as I said before, is strikingly similar to this case. Finally, I guess I'll comment on the history of this. This issue has not been appealed before. Mr. Pryor and a group of abutters appealed the decision to merge the lots as an end run around this board's determination that the project would not receive a use variance. Okay, there has been no final determination as to this issue, and there has been no appeal as to this issue. But, I mean, further, when we're considering this, it's what necessarily was going to be appealed and what would have been reasonable to the average person who's not a lawyer, that there had been some determination that special exception is not required. Riverwoods applied for a use variance. It was denied. If you're opposed to this project, you're not going to appeal that. You were victorious. Riverwoods then, frankly, in a very crafty legal move, I think, merged all its properties, which I think is improper, actually, because it's bifurcated by a highway, but that's different, and then applied for a variance for, I think, a variance from the height requirements. Height and setback. That was denied as well. So if you're opposed to this project, what indication are you receiving that this project doesn't require a special exception, especially since zoning can be iterative?
I guess I don't know that I buy that. I mean, once that Riverwoods was going forward with relief for dimensional requirements, how could the use not? I mean, I don't.
Oh no!
When an appeal was, the whole issue with the merger was one of use. So I mean, I understand. I don't see how. If you're arguing that.
Well, let's talk about that.
Yeah, but I mean, if you are arguing that, there was no way to know that this, what use was going forward.
I'm saying it's not intuitive to the average person, and I don't think it's even intuitive to a land use attorney, particularly if you consider this, that there's nothing in the ordinances or the regulations that I've seen that requires an applicant to bring every single variance issue that it may want at once. I have seen it before where a developer brings requests iteratively.
I understand your argument.
Okay?
We've seen it here.
It's not uncommon, and there actually is a strategy behind that. So I wouldn't say that just the fact that you're talking about dimensional issues means that everything else has been approved. And I guess I'll give one final example, and it's a hypothetical. But it also deals with, actually, I'll strike that because it's going to go into a crazy hypothetical. But what I would say is, with respect to Mr. Eastman's letter, we're not appealing that. We're appealing the decision of the planning board. Under the Exeter site plan review regulations, the planning board has an independent obligation to make sure that what it's approving is compliant with the zoning ordinance. Just like under, I think it's RSA 676-13, a building permit cannot even issue unless a property is compliant, right? And I see nothing in Mr. Eastman's letter that would indicate that the project is compliant from a special exception requirement, and nothing in that letter that would, in my opinion, give Riverwoods any type of municipal estoppel defense. If it were to become an issue where a new code enforcement officer says, no, this project actually isn't compliant. And I understand Attorney Bolt's point that, Riverwoods has been through this process and, has expended capital going through the site plan review process. And I understand the point, but I'm not sympathetic to it. I'm not sympathetic to that because Riverwoods has extremely competent counsel in this case. And it is inconceivable to me that Riverwoods didn't know about this special exception issue, but chose not to address it. And now it has to address it here on an appeal from the planning board. And I'll end there.
Briefly, Madam Chair.
Excuse me, point of order. I believe that the normal procedure, excuse me, Mr. Bolt, point of order is that the normal procedure is to open it up to public comment, which is what Mr. Bolt has provided, and then the applicant, in this case, Attorney Bouchard, has an opportunity to rebut. This is not a debate. I believe that we've just heard the summation.
We've heard, if we choose to hear more, we certainly can. This is our opportunity, so we've done it in the past.
Yeah, we've done it in the past, so just brief.
Briefly. Mr. Pryor made my point. By no means is he unaware of the processes that this town goes through. He could have, should have, timely brought his concern about Mr. Eastman's letter back a year ago. He chose not to. Thank you, but that means he's passed on the jurisdiction. All that knew or should have known via what he knew at that time. I also take umbrage with the trying to distinguish accurate. If you look on page 3, top of the page, the court emphasizes the words written decision. It then on page 5, says, however, the code enforcement officer, however, never made such a decision. That alone distinguishes accurate from what we have here with Mr. Eastman's letter. This is an issue that was not appealed before. I agree with Attorney Bouchard, but it should have been and could have been. And our case law clearly says if you do not timely bring an appeal of administrative decision, it is barred. And we say that you have no jurisdiction. Thank you for your indulgence.
Mr. Bolt is pretending to know what I think and what I know. I can assure you he does not. At the point at which I became aware of this letter, which is not in dispute, and as Attorney Bouchard has said, we are not appealing the March 4th letter. At the point at which I became aware of that letter, I read that letter, and I realized that it only dealt with use variance. And that is why I did not bring this type of an action at that time. Further downstream, and in ultimately an untimely manner, I did appeal the use variance request, the merger, rather. I never imagined that the project of this scale in the R1 zoning district would be allowed to proceed without a special exception. My operating assumption has always been that a special exception was going to be requested and was going to have to be acted upon by the Zoning Board of Adjustment. It is inconceivable to me to this day that a project of this magnitude could proceed to be constructed and approved without zoning board taking affirmative action on a special exception. That is inconvertible as far as I'm concerned. I think I've just used the wrong word, but I hope you know what I intended there. Getting tongue-tied. So thank you for indulging me for a moment there. Did you wish to provide a summary
I think
again?
at this point, the dog is starting to chase its own tail.
Mr. Pryor ignores the matter of right language.
Attorney Ball.
Every time Attorney Bolt speaks, I'm going to take the opportunity to say that that the appellants have the right to reply. So we need to put a stop to this. It's not a debate.
We're trying to.
Okay.
Are we in public session? Am I allowed to speak? Public
I think-
session's different from public comment? Okay. Are we in public comment?
We
We went through that already.
Then it's not ended. Okay. Thank you.
Okay, so we ready to close public session and discuss?
I'm good.
Okay. You good, Kevin? You're,
Yeah, I'm,
okay.
yes.
So now deliberations.
And again, this is with respect to the jurisdictional question only.
Only, yes. Is there anything we would like to discuss?
I mean, this is very complex. I can't pretend to know which attorney is correct here. I'm a humble real estate appraiser, and I don't know. I feel that jurisdiction's been used to shut down every concern about this process throughout, and I see it happening again, and it frustrates me. I don't know if that's an adequate reason, but I don't know legally the way through these arguments. So that is how I'm going to make my decision.
Yeah, I mean, I think, my thinking is there has to be finality. That's the point of this whole jurisdictional issue, is whether there was a timely appeal. There's a lot of, it seems to me that they're not appealing the Doug Eastman's administrative decision, but it all gets back to the administrative decision. In my mind, and I look through the minutes, like all minutes, we'd always like them to be clearer.
They were
but-
not our best.
Well, I'm talking about the planning board minutes.
Oh, okay.
And, to me, it does seem to line up with this Andrews case. There's a statement made that planning board didn't rely on Doug Eastman's decision. It seems to me they did. I mean, there wasn't an express vote, but I just looking, there was a discussion whether, Page 3, 125, Mrs. Belanger indicated she didn't want to put words in his mouth. She felt Mr. Eastman would have spoken up and said if it was needed, I think we can move on. Mr. Kennedy, line 129, Mr. Kennedy said he was hearing staff say it was not required. Mr. Sarple said it. Next page, line 131, Mr. Sharple stated he did not have anything in writing, but it was discussed. No one missed it. The ball was not drawn. It was discussed and decided. Line, so I mentioned before, line 151, Mr. Gruder noted the building inspector said they don't need it. So it seems to me that they did rely in ultimately deciding, the majority of that board decided in reliance on that letter that a special exception wasn't needed. I think those are sort of the facts that are presented in Andrews. I mean, we had a administrative appeal. We determined that it was untimely. That administrative appeal's gone to court, as I understand it. It's been upheld. I do think there has to be some finality, and in this case, it is really. I mean, I understand the legal argument for it, and I appreciate it. But I think ultimately what we get down to is this is a de facto appeal of the Doug Eastman's determination, which we've already determined was untimely. So that's where my thinking goes.
I would be in agreement with that. Any more discussion?
I think to Kevin's point, the accurate case is distinguishable from what we have here on when we had an appealable decision. And I think here we had an appealable decision when it was issued by code enforcement, and to go back now, it's slightly different facts than the accurate case, which was based on an opinion that wasn't ripe for appeal until it made it to the planning board. And I'll also mention, I don't think that standing is an issue here that would prevent us from moving forward, just to cover that.
Yeah, I agree.
We're currently just talking about jurisdiction, right?
Yes.
Just ruling on whether or not we have jurisdiction based on what?
Yes.
Right.
Timeliness.
So timing and standing.
Sorry.
Yeah.
Not lawyers. There's no more discussion. I'll take a motion.
I guess I would move to deny the appeal based on a lack of jurisdiction for the reasons I've mentioned, which is that this is ultimately a de facto appeal of the administrative decision. And again, I note that determination was that the use was permitted by right. I know that there's been some parsing of special exception versus use variance, but in my mind, that's a pretty clear statement, and especially in light of what I think everyone knew was coming, which was this proposed healthcare center. That administrative decision was previously appealed and dismissed as untimely, and that dismissal was affirmed by the Superior Court. The planning board, similar to the Andrews case, made a decision not based on the terms of the zoning ordinance, but really in reliance and based on Mr. Eastman's administrative decision, which was at that point and this point no longer appealable. I would note, too, for the record, that this is for jurisdiction, pertaining to jurisdiction only. We are not making a determination on the merits of whether a special exception is needed or would be needed in the future. It's just on the specifics of this case. I think that was maybe the most wordy motion ever. So I'll leave it there.
All in favor?
Oh, we need a second.
Oh, sorry.
I'll second.
Any discussion? 'Cause
I'll say, as a zoning board member, it was not clear to me that Doug Eastman's letter had anything to do with a special exception. And I read it carefully many times. So it wasn't all that clear. It might have been clear to you as a land use attorney, but it wasn't clear to most people.
No, I appreciate it. I mean, in my mind, just so you know where my thinking is that given the context of the opposition, given that there had already been a fight over that use,
And a decision.
And a denial.
Yeah.
Right? And a denial. And then coming forward after that, where I think everyone knew that Riverwoods, agree with it or not, they had merged, and to avoid the use variance.
We knew that that their intent was to go forward, but that they would be successful in avoiding a use variance was not clear to me.
Yeah, I guess.
Not at all. And I met with Doug and I met with Dave twice and talked about it, and it still wasn't clear to me that there was even, so no, it was not clear. So we'll leave it there.
Okay.
Not to the average person. So, but anyway, that's your motion, and
It was seconded. So all in favor?
Aye.
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 I'm opposed.
Okay, so the application for administrative decision has been denied? 4-1.
Thank you, folks.
Thank you.
Thank you.
And we suspect people don't want to sit here anymore, that's fine, but we are still open, so if you could leave quietly, it would be appreciated.
I have to go back.
Oh, yeah.
Yes, run away.
Yeah, thank you.
Thank you.
Thanks, Dave.
The vote?
What do I do with my?
Have a second.
We'll get started in a minute.
Yeah, you too. Thanks.
The ironies of my presence.
Welcome back. This isn't awkward at all.
Screw all of you.
I hate you.
Oh. Great to meet you. Great to meet you. I know. That's the. I lucked out. I fell into him and lucked out as well. They're great. Yeah.
Everybody concerned with this. Should get in the car.
Yeah, well,
It's preposterous.
the way it is now.
Okay, we ready for other business?
You get a private letter, you can't do anything about it.
I'm not sure.
Let's let the room clear. Thank you.
Yeah, it's close.
That was fun. Oh, this is
I
interesting.
need to fucking breathe. I said I need to breathe.
Somebody forgot their jacket. They'll come back.
I'll be back. Be ready when you are.
Okay. So the first piece of other business is a request for rehearing from J. Cayley Associates, ZBA case 24-11 for 97 Portsmouth Ave, tax map parcel 65-125. Does Doug want to fill us in on what's going on with this project? Because it might help us with this request for appeal.
It can't be more.
That, I don't think
Actually, the
that.
last one was not very confusing for me.
Okay.
It was but
Focus.
anyways, don't do
Yeah.
that.
Let's not.
Let's not go down there.
Between the two of you. No comments.
When you hear
No
your
comments.
name,
Okay,
when you
Doug.
hear your name brought up.
Let's,
That's all right.
Okay.
You gotta.
Here we go.
yeah.
So,
97 Portsmouth Ave.
Yeah, so you guys granted a variance for expansion of a non-conforming use, which was a side yard setback. You remember we wanted to do the
Yep.
50-foot, you gave them a variance for the height and the expansion on the side. And since,
It wasn't the expansion,
It
it was
wasn't an
within the same footprint.
within the same footprint.
yeah, but the expansion was in the vertical position.
Oh,
On the side, in the vertical
Yes.
position?
Yes, because the building was only 16 feet tall that encroached.
We gave a
Okay,
special
I-
exception
So when
for
you
the
go-
height and a variance for the side
Expansion.
yard setbacks.
Yes.
The setback was not changing.
Correct.
But when you're encroaching on the setback, and it's grandfathered, and you want to go higher than what's allowed in the zone, it's expansion of a non-conforming
Okay.
use.
Okay.
We got it, we're there.
All right?
Yep.
Okay. So, that was fine. Everything went,
Fine.
and then things went awry. You all aware of the MUND, which
No.
the town has adopted years ago, okay? So the applicant caught wind of that and decided that they were going to go with the MUND now.
Have they withdrawn?
No.
Can we not use the acronym? Can we use the full?
Oh, I'm sorry.
I thought they did withdraw because,
The last, they.
no, in
they
the
had-
last meeting.
Yeah, but that was just for one other,
That's when the mom withdrew it.
they asked for a variance from
Come up
it,
here.
Yeah.
and then they withdrew it.
They
But
had filed a second variance
But they still have,
because they needed relief for the minimum setback or maximum, I forget. But they basically, they needed additional relief. They pulled that. I mean, I think for us tonight, if this is still a valid and active variance approval,
I think they withdrew that variance.
no, that one. I'm talking
the
about
original one.
the original.
Oh, the
The
original.
original one is still
It's
valid.
still valid, yes, that's correct.
Last month, they asked for
Yeah.
a variance for relief from the maximum front yard setback requirement under the MUND
Yes.
mixed-use neighborhood development ordinance.
Yeah,
Thank you.
This case was withdrawn at the applicant's
correct.
request.
Thank you.
So that's off the table.
Yes,
Right.
that is correct.
So we're back to the original
So-
Yep.
as approved.
Yeah, under the MUND, they can't go, they can be right on the front property line, but they can't go any further than 20 feet back. So, so where are we now?
Well,
The motion
So
for,
then comes the people that own the mall,
correct,
okay? They're not abutters,
correct.
but they found out about it and in time and decided to file an appeal on the original request that they had.
As part of the original application.
Yes.
The applicant did mention in response to somebody's query, I don't know who it was, it might have been mine.
I think it was,
There were several.
About parking.
yes.
Oh.
They said, don't worry about it, just because there isn't enough parking on site, because we have an agreement with the owner of the mall to provide additional parking. But there was no legal testimony, there was only the word of J. Cayley and Associates.
Correct.
Well,
And I think there's something.
no, I think there was an easement referenced on the paperwork
There
too.
is.
It's very small, but there is, I can't find it because the print is really, really
I found
small.
it. It is
But
there.
It is on there. There is a reference to an easement.
For parking.
For multiple parcels to park upon the shopping center lot, and it is not a
And
very,
It's not-
plain manner as well.
yes,
There was
that's one of the other parcels.
Yep.
It's not very clear.
Well, so did, even the appeal council doesn't offer us a copy of the easement language, which was recorded in the registry. So I did not have time to look that up myself, but to
Yeah.
me, we need to know what the easement says.
I agree.
To know, but
Well, I
the
don't-
decision wasn't about parking, it was about the height.
Right.
And that's my question. Why do we have to rehear on a variance about setbacks and height when this issue is about parking?
Yeah.
And if there's not enough parking, should they not be coming forward for a variance on parking?
Yes. I mean, that's I agree. I mean,
They would,
They
but if-
keep talking,
But-
the
But it's
petition,
under a MUND, so now they can,
There's
Right.
no parking
so
requirement.
now it just kind of like goes directly to the planning board. And the planning board, if they can prove to the planning board that they have,
right.
because under the MUND, the parking requirements go way down.
But that's the planning
So-
board's concern. I mean, I think
We're
that
never-
this, to me, this
And
this
planning and
request,
zoning never meet.
the request, I mean, in my mind, the request for rehearing keeps talking about use. We didn't grant a use variance.
Correct.
We granted dimensional relief.
Right.
Yep.
We did ask about parking, no question. But, I think ultimately, what they're claiming it was sort of error because there isn't enough parking. But again, in my mind, it's the applicant's issue. It's a private dispute over the scope of an easement and whether that easement's being overburdened. I think that's ultimately a private dispute. Whether the planning board takes it up or not, I don't know. I mean, the other thing they raised the only thing I thought that they raised that was relevant to what we granted was the concern about fire department access, because that is relevant to the expansion of the both the height and the expansion of the non-conforming use in the setbacks. But again, to me, that's also a planning board issue.
I thought another planning board issue that they raised was, traffic flow and
Safety.
Crosswalks and safety and pedestrian traffic, which was not contemplated at all at the time the easement was granted and is a separate issue anyway. So I think there's a bunch of things that should be considered by the planning board, and they should have a copy of the easement presented to them to understand what actually the rights are, not just as described by the applicant. But none of this is related to
Us?
Well, I wasn't there, but to the decision about
Agreed.
height and
Yeah.
setback.
Look, I don't want to tangle with this, but is the fact that we heard testimony during our hearing, even though we didn't make a decision about parking, but we did hear testimony, is the fact that we heard that testimony at all a mitigating factor for anyone? And I'm saying that I don't necessarily think that we should hear this. I just want to make sure that we're careful with the decision.
Yeah, I think if we heard testimony that was relevant to our decision, then it's a different that's what they said was that they have an easement that allows parking, and I think that's still a accurate statement. That is not, what the appellants here are saying, or the petitioners are saying, is that, they were going to overburden it with their use. But
They're not denying that there's an easement.
not denying that there's an easement.
Right.
Yep.
And, and in my mind, we asked about, I think we did ask some questions about that traffic flow and whether there was sufficient parking. But at the end of the day, that was really not what we hung our hat on in making our decision.
Well, it
So-
is to an extent. As you say, it's an expansion of a non-conforming use, and it's obvious that the intended use of the property is going to place a considerable burden on parking that does not exist with the current use. So the expansion of the non-conforming use
And the
is
height.
not just square footage, it's going to place a burden on the parking. So I think that had we not heard that, I'm not sure I would have voted in favor of the,
If we hadn't heard that there was an easement, is that what you're saying?
no, that we heard that there was an easement that allowed for, we were essentially presented with a case
Correct.
that, don't worry about parking, there's
We
an
have an
easement,
easement.
people will park in the lot in
No.
front of Margaritas.
Yep.
Yeah.
So that's what we were
And if you
presented.
read the easement,
They didn't
that's what
ju-
it
They
says.
didn't really justify that, in my opinion.
Did you read the easement?
Well, just what,
No, I'm
it
saying
says
that
on
we
there, there's
didn't, oh, did you read the easement?
I didn't get the full easement, but there is an easement for parking. Nobody's denying that.
Right,
Yeah.
they're not.
It's just,
But
So-
there's no
it's the,
number.
the extent, because it was written in the 60s.
Based on what it says on the site plan, you can't tell if there's any specifics about numbers and location of parking.
And the
But it might say that in the easement document. We don't
Preceded
know
zoning and it
because
preceded the
we
mo-
don't have it.
So-
But I think the height variance is relative to the intensity of use, which goes to parking. So, it is, I hear what Bob's saying. If
It
you,
really is part of it,
it is part of it,
because
a
they're
little bit.
adding more.
But
Because they
to
couldn't-
Kevin's point, isn't that then the role of planning, right? So they didn't come forward to us with a variance for parking. They don't have to because of MUND, correct? So if Planning goes for, planning looks at parking as well.
Yep.
And if planning deems that they review the easement and they say this easement does not qualify and this does not give you enough parking, then the applicant would have to come back to us for a variance on parking. Is that not how the process would
It's not
work?
going to work that way because Doug said the MUN doesn't have extensive parking requirements.
What are the,
So the,
Well, I mean,
so the height
if it's
variance,
really out of balance, then I would agree that, if
It
the planning
might.
board determines, hey, you don't have enough parking.
I just think we have to be careful because we didn't decide use. So, I mean, we decided height, we didn't decide use, they could build it and put, self-storage in there, which would have a much less, I mean, we didn't address that issue. I get the fact that they discussed it, they presented it themselves, we certainly considered it, but I just,
The application was for a use
it was
that was
specific.
different than the existing use.
Was it for use?
It wasn't a
Well,
use.
yeah, no, the use was permitted.
the request wasn't for use, but it presented.
It presented, this is going to be what they called a micro hotel, which I don't even know if that's a legal term, but.
So, and the height variance is what allowed that use. So it really wouldn't have been a practical use for the property without the height variance. So it is kind of tied together. And as an aggrieved party who owns in fee their parking lot and feels that, this decision is going to open the door, and then when it goes to the planning board, they're going to say, potentially, the zoning board said it's okay, so, and the MUN doesn't allow us to restrict it based on parking. So it's potentially going to be a mess for the people who actually own the parking area.
Yeah,
Case
although-
2411 does not refer to the MUND. We shouldn't be talking about the MUND. They are asking us to rehear ZBA case 24-11, which has no reference whatsoever to the MUND. If they withdraw 2411 and go under the MUND, then this goes away.
Is that how it works? You have to identify the overlay zone?
They are asking us to rehear case 24-11, which has nothing to do with the MUND. The MUND was not mentioned in that.
But it's still the zoning district, isn't it?
Can I?
I don't know.
Yeah, I mean, I think if we deny this and the variance stands, they have that variance. Whether they ever, then they have 2 years to use it, but they have it in hand and they can make up their mind later about whether they use it or not. I don't think it necessarily goes away, even if they apply. I mean, I think the only way it goes away is if they never, apply.
Well, if they get
utilizing the
planning board
variance.
approval to do what they want to do, then those variances, I would say, go away.
Yeah, I mean, after 2 years, they go,
Except.
yeah. But
If they do get planning board approval, the variance goes away? I'm sorry.
Because there's something else exists
would
on
say
the
so,
property.
yes.
Yeah.
Oh, for another use, you mean?
Yeah, because something else is
yeah,
going to exist.
well, I mean, they exist until they expire. So, but
Yeah, 2, 3 years, whatever,
yeah, I just want to be clear, if they go, them filing an application with the planning board for a totally different proposal that doesn't utilize this relief, doesn't
Extinguish.
Make the relief go away.
extinguish those variances. They could still withdraw and go under them, so. But I'm not sure, just to clarify that, but I'm not sure it matters. I mean, in my mind, I've always, my understanding has always been to sort of tread lightly when dealing with disputes, like private disputes over like the scope of an easement, because it puts us, we can't really adjudicate that.
Yeah.
If in fact this, REL Commons is correct, that they've, this proposal overburdens their easement, that's for a court to decide.
Agreed.
And determine, and then it's a fight over, because otherwise we're not in a position to
Right.
do it. And again, in my mind, I know that it was sort of tenuously discussed, but I don't think ultimately for me at least, the decision didn't really rely on the parking. I mean, it was.
I wasn't here, so.
Yeah,
So-
I would agree with that.
Accept
And this
that.
is,
I would agree with that.
this is also not timely.
Yeah, that was
Oh, is
the other
it?
issue. Well,
I thought it came in like just in time.
No,
There was.
because the decision was made. When was 2411 decided?
Well, they had a continuance. I think it wasn't in,
It was
The
decided
decision was
in-
made.
It was
No.
not decided in April, it was decided in March.
March 18th.
Yeah.
And the letter came in April 17th.
April
18th.
7th.
Okay, they got
Yeah.
it, never
But
mind.
they-
I thought that too, I'm like,
They were the
ooh.
last day, I think.
Yeah,
They
okay,
did
no, that's fine.
flag the issue. My client did not receive notice of the application.
They're not a butter.
they're not a butters.
Okay.
Yeah.
Wanted to
Oh, they
make
say
sure
it right
that
here,
was
I
okay.
apologize, March 18th, right there.
I think they were just saying that to say why they didn't come. I mean, there were two hearings. They didn't come
They
to
didn't
either, but I
attend.
think that's.
Do they
why.
have standing to request a rehearing?
That's reassuring.
Mr. Sensitive to these issues here, you see.
And you,
I,
Because they're not a butters, but they are impacted greatly.
Yeah.
I mean, if you-
because they're,
Persons aggrieved?
because it's associated with some sort of a document out there that affects all four properties, I guess to be on the safe side, because we should always try not to err in any decisions and be, really positive and maybe just do it, say, sure.
yeah, I think,
Because the abutters, I mean, who owns Margarita's, the mall, they have serious, they have parking issues right now because the Thirsty Moose sometimes takes advantage of their parking because of the auto parts store, that's gone, so.
I mean, I think the answer is, well, I don't think we know, but I don't think we know enough that I'd feel comfortable saying they don't have standing. I mean, I know in the last one, we had two attorneys with very different interpretations of what the new statute says. I don't know the answer. They didn't participate, which is a factor, but at the end of the day, we have nothing from the applicant either that received the variance. I mean, to me, it's their burden if they don't think they have standing to make that argument. They didn't.
Well, and both parties agree that there was an easement. So this really is a dispute between them and the scope of their easement.
Let's play this out. We say yes, we grant the rehearing, and the applicant says, this pushes the hand of the applicant, of J. Cayley and Associates, whatever the name
Yep,
is.
yep.
They say, oh, never mind, we don't need it, we're going in under the MUND, we withdraw 2411. Okay? Or if we say no, and we leave ourselves open, as far as I'm concerned, to a question of interpretation here. We've kind of just agreed that this REL Commons has standing to request an appeal, a rehearing. And I would be concerned about not giving them an opportunity to speak, which can only take place if we have a hearing on the case. So with that said, if you're willing to accept a motion.
Before you make a motion, I'm just
How come
going
your
to.
microphone works
Yeah,
so
your
well?
microphone is like the loudest.
But
She turned
probably
hers on.
Yeah.
somebody decided that I'm too quiet and
There's no on or off
be the
button.
loud
They-
one.
Oh, there
Yeah.
isn't?
We're
No,
going to
there's no-
mic the only
The
person
old one
that-
had on-off buttons.
Oh, does it?
No, who does it?
Hot mic
Doesn't, I don't
situation.
think.
Sorry, Teresa.
I wasn't present for the meeting, either of the two, so I'll suggest that I not vote on the issue, because I think both Mark and
Laura.
Yeah, Laura.
Laura.
Yeah, I was,
were
Laura.
here,
Yeah.
and I think you might be in the same boat as me, so.
Yeah, I did not, I'm not going to vote on
So
this.
maybe we have alternates.
I was here.
Yeah.
I was here.
no, I
I
think,
think
I mean-
it's Laura and I.
Yeah, and I guess the only other thing I would say before we make a motion on this is just, let's recall the standard for a motion for rehearing, which is, was there an issue of fact that wasn't available or overlooked, or an error in law or interpretation of the ordinance? So,
Under the former, I think don't you think that this is new information that we did not have at that time?
I don't know that it is an irrelevant manner. I mean, we knew this easement existed. I mean, we knew the easement existed, and to me, if it's a question of, if it's a question of what are the rights under the easement, that's a private issue for them to figure out. And so the town can give all the approvals they need, but at the end of the day, they're going to be limited by the terms of that easement. And that's for either them to fight, for them to fight out for a court to decide, or for them to come to some agreement.
I understand Kevin's point, but I still maintain that our decision to expand a non-conforming use was based in part on the existence of the easement.
And the easement still exists.
Yep.
That hasn't changed. They're just saying, our easement, we have an easement, but we don't have enough parking.
And
Maybe we should have requested it at the time, but we
Yeah.
didn't.
Yeah, well,
And I mean, oh, sorry.
there was question about the easement, and I think the applicant did give a summary, and I'm saying this based off the minutes and watching it, because I
Yeah,
just
he
said I
did.
wasn't present, but
He did read from it, and
Yeah.
and of course I
It is,
didn't,
and it's-
we had approved those minutes, I didn't bring them.
No, I
so.
don't
Yeah, and
Oh,
I remember
have
being
them.
vague.
it was somewhat vague, but he did say that it wasn't dependent on numbers specifically, and that it did provide for some kind of expansion based on development. So he gave at least a summary of what.
There was an
Interpretation.
assurance made that we did not need to be concerned about parking.
Yes.
I mean, I guess the question, so to further parse it out, really, we had two grounds for relief. We granted a special exception for the height, and that's probably, and then the expansion for the, basically to go vertically within the setback.
So,
I think probably this issue goes more to the special exception, but in those criteria than to the, because I think once we granted, the issue was the height, and once we granted the height, I don't think we had any concerns about going up, within those side setbacks. I mean, that to me, the issue there is really, further encroachment, shading, privacy, that type of thing, which really isn't impacted by the
More
parking
square
easement.
footage, more units, more parking.
so I did bring the minutes from the March 18th meeting. Yes. And it says, Attorney Lanzetta said regarding parking on the existing conditions plan, there's a note that references deed 1712, which grants a broad sweeping access easement for this property and 3 others, and a broad right to park. It grants the right to park at that time and for future development on the granted premises. In his opinion, the easement is valid, legal, and broad, and so he does not think the parking will be an issue. So that's what was in the minutes from the attorney.
It's pretty detailed.
And they
But they're not
further went,
arguing
it will
that
be
the
addressed in
easement
full at planning board.
They're not arguing the easement exists. They're not arguing that their use isn't going to conform with the easement. They're just saying that because we granted so many more spaces, they're going to need more spaces, and that's going to put an undue burden on them. But is that for us to decide?
Yes.
No.
Wait,
I don't
it's
think in
for
this
us to
case.
decide
But
if it's
it's-
going to put an undue burden on their
easement.
easement?
No, we can't decide that, but
Yeah.
that's.
Thank you
we
for
don't-
reading that. You've just flipped me.
That's why I brought it.
You've just flipped me.
you
Okay,
know,
so do we
haven't even,
have,
I mean, that's a characterization, we haven't even seen the document, but,
Yeah.
and it's not our place anyway.
Yeah.
But
So why would we?
was that information relied upon to grant the height variance and the expansion and the non-conform?
But I guess, again, there's no new information. He didn't, in their request, they didn't go, the easement says this, they have 5 spots.
And they're-
And then that'd be new information.
They're
Yeah,
not taking
okay.
issue with the description of the easement by the applicant, if I'm understanding it correctly.
They have not
Yeah.
addressed that at all.
Which is the only thing I considered when I was, there's an easement. And there's nothing specific about the easement that says you only have 1 row or something.
I'm back to thinking the planning board needs to consider
Yeah.
all the access and crosswalk and parking
Yeah.
issues, not us.
Fire
Well,
access
I
is
completely
technical
agree. I mean,
review.
I'm just looking at what's in the request. And
Yeah.
It talks about, the development of surrounding properties has been such that both car and foot traffic between adjoining lots raises the specter of safety concerns. The intersection between the bank and the main entrance to Exeter Commons is such that they don't, it's really a cut through. They lacks lateral access, less improvements, sidewalks, crosswalks for pedestrian. I mean, that's all planning stuff.
It did seem a little bit like that if the Blue Ribbon Cleaners were more profitable and had more business coming in, that they would probably be running into the same issues as parking and everything.
Like,
Those
They're
issues,
kind
Kevin,
of saying that, like,
you just described, those
The
were
owners were
known
not so damn old.
at the time. That was the description they were giving, was that the parking would overflow into the
Yes.
easement.
Yeah.
So
Yes.
all of those potential problems that were just described were, that was the known situation at the time it was decided.
Yeah. I mean, I just, again, as I look at it, the only thing really relative to height, specific to height, that they talk about is risk of fire trucks.
And that's
But isn't
technical
that-
review.
That's technical review and planning.
We don't
Right.
touch that. Well,
Anybody want to give a motion?
sure. Madam Chair, I would make a motion that we deny the request for a rehearing on ZBA case 24-11.
I'll second that.
All in favor?
Aye.
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 Aye. Okay, request denied, 5-0.
Laura, your microphone works too.
That's because I'm speaking into the microphone.
Am I not? Oh,
There
whoa.
you go.
Right here?
What is
This how close I have to be.
What's in your mouth?
Yeah, just eat it.
This is unhygienic right here. This is
Someone's giving you a hint.
Yeah, who normally sits in this chair for select board?
Okay. We're not done. We're getting punchy, but we're not done. Next up,
You're getting punchy.
election of officers, because it is May.
Oh,
So we have some shortcomings because Teresa thinks she's leaving us, so we can't put her on anything, and she doesn't get to be vice chair anymore.
No.
So is there any news on your new life?
Yeah,
That you
we're,
plan-
It's happening.
Have you sold the house?
oh, we're working on it. It's
Okay.
in the works,
Okay,
knocking on wood.
okay.
what's happening?
Anything. So-
He's leaving us.
So we can't just.
We can't
punt
just, you're
this
now chair.
decision
No,
and-
can't. So that leaves 4 of us who can be, what are we, elected officials, officers?
And unfortunately, only regular members can vote on officers.
Yep, so that leaves Kevin, Bob, myself, and Ms. Davies, not to confuse the Laura's. You're currently clerk. Do you like that position, or do you want to move on? Because if you want to move on, that means it's myself, Bob, or Kevin.
Laura, you're a clerk, I think.
no, oh,
Yeah,
this
the-
Laura
the
is.
sign was
Oh, okay.
Misplaced.
misplaced.
Wrong.
But I
Nice
am
try,
clerk.
Teresa.
Well, I made no correction because I hadn't seen Esther yet, so I was like.
I thought you're not an officer?
She's vice chair.
Vice chair.
Who got in here first?
Yeah, who's
I
messing
guess-
with the things?
I know I'm not. I'm curious.
Well, luckily, it didn't come up.
So I know
You're clerk.
I believe so.
Laura's clerk,
I
You are now.
until we vote, yes.
You are now.
and I know Kevin has time problems sometimes, but I will also say clerk is, if we get down the clerk, we probably have bigger issues.
Yeah, I mean, I'd be fine to be clerk. I mean, my issue has always been I miss, I go in spurts and I miss a lot of meetings. And that's going to continue to happen just because of my work directly conflicts with evening meetings.
So what are you asking me, Esther?
I'm trying to figure out who wants to be what. I'm going to try to, I can force chair on you, or I can force chair on Bob.
You mean vice chair? Are
Well-
you staying as chair?
No, I'm forcing it off of me because we tend to only do 1 year at a time.
Oh.
So I need to move on.
Boy, am I really glad.
Okay, well,
Fight it out.
I'd be happy to be chair.
I would be okay being vice chair.
There you go.
And you can be clerk, Kevin, is that okay?
That sounds great.
Maybe we should
Unless
vote
you
on
want
this.
to, unless you
Yeah, we
want to
should
move
vote.
to a different office, Esther.
I'm game for anything.
Would you prefer that, Kevin, if she were?
Oh, to be clerk?
No, that she be clerk.
Oh, I don't care. I'm not, Yeah. That, if you would like to be clerk, that's fine.
What
I
does
don't really
clerk
understand
do?
what the clerk.
I was going to say, what does
third
the
in line
clerk
if you
do?
End of the throne.
I asked that when they voted me clerk, and they said that it's like you're third up for
Yeah, you're-
running a meeting.
Yeah.
You run the meetings if
If you-
nobody else is alive.
There's
Yeah.
no clerk-like duties involved
Yeah.
in the clerk
I think
position.
if there's a issue with the minutes, which came up once when I was clerk.
Oh, is that the clerk's job?
Yeah.
Well,
Clerk will preside in absence of the chair and vice chair. The clerk is responsible for recording of meeting minutes in the absence of the planning department clerical supervisor or office clerk.
So there you have it.
But that's never happened. There's no way our staff would be missing
and the
Well, we
clerks
have
didn't even
somebody
know
to
that
do
was
that.
their
Yeah,
job.
exactly.
Yeah.
off of the tape, so it's not an issue.
Yep.
Yeah.
Okay. So,
Since your name is not on the list right now, why don't you make the motion?
Okay. I will move to elect the following slate of officers: Bob Pryor, Chair; Laura Davies, Vice Chair; and Esther Olson Murphy, Clerk.
Second. Can I can second?
Yeah.
Second. I will second the
I
motion.
thought when somebody up for a vote shouldn't second.
Yeah.
All
All in favor?
Aye.
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 Okay.
All right.
New officials are set. Last thing, approval of minutes from April 17th.
Step number one, the
Yeah.
date
Date is wrong.
Step number two, on line 173, I doubt very much that I made a motion to continue my own.
Yes, I noticed that.
So I'm
Mr.
guessing,
Pryor made a motion to continue I believe you did. Yeah.
You agreed to the.
I agree to it. I don't remember. It wouldn't surprise me if I did it, but it says that I agreed to it.
I agree. Brian and I sat there and agreed that, yes, we're going to continue until next month because there is not five-member board, but I did not make the motion, so another name.
Well, it was either Laura or.
Well, I'm guessing it was a boy.
Because Esther seconded, so it was either Laura,
I'm going to go with a boy.
Kevin, or Mark. Mark, do you remember making a motion?
Oh, I don't talk if I don't have
It was
Okay.
probably,
Then it was Kevin.
honestly,
It was
I
probably
talked
Kevin.
Too much, as I did tonight, so it was probably.
It was perfect.
I mean, that would make sense. And
Well, it wasn't too much.
There's another,
Issues to be.
You have another one?
I have other stuff too, so go ahead.
no, that's
Laura.
okay. Go ahead.
I'll get by this someday.
And this is unusual. So,
9:30.
like line 79, in the future, this is me talking, in the future, someone could come back about converting this to living space. There is already a garage. There's already an attached three-car garage, I think was what was said, and it's relevant, so I would like that in.
No, I don't think that's what, no, you were talking about that, what they were proposing was a garage.
No,
You
but I'm
weren't
saying
talking
they
about-
already have a three-car garage, which is fine, because it's a lot of garage space.
79.
I wasn't trying to criticize that they have a three-car garage, but it seems like they don't need the second garage for their
Just-
primary
I got
garage.
your
It's their
point was
secondary.
they already had a garage. And so
Exactly.
what, they're not using this as, are they going to use this as a garage, or are they going to come back and say, hey,
Well,
we
they're
want
going to use it for storage for the immediate term until the law passes for more than one accessory dwelling unit, and then there's going to be a bunch of them on that
You can do
property.
a conversion.
Or a conversion, so.
You can do that by right.
So you
if
want to
if
amend
he-
this to
If he
say
wants to
an
do that
attached?
outside of the setback, he can do that by right.
Correct.
He wants to put it 5 feet from his property, from his abutter's property line,
much
which
land do
makes
you have?
no sense.
11 acres.
And that's my point, is that it's one thing to think that
Crowd thing.
you get your abutter to write a letter agreeing that a storage building can be next door, but when 5 kids live there and there's stuff everywhere and whatever, it's a different story, and
Is
that's.
this going to come back
So we're going to update that to there is.
already?
There is an attached three-car garage.
Yes.
So
There is already an attached three-car garage.
that's line 80. Okay.
Okay, so that's the first comment, and then I think on line 160, the application of the pickpocket abutter group for an appeal from a zoning board decision, not an administrative decision.
No, it is an appeal.
No, a planning board decision.
But it's still an appeal of an administrative.
It is?
Made by
Yeah.
the
Made by the
Made by
planning
the-
board.
Okay.
No, I looked at that, it's right,
It is? Okay.
yeah.
Wasn't sure. I thought I had one more thing. Oh, no, it was you're making a motion when you're.
Sitting in front of us.
Yep. Okay, that's it for me.
Okay.
Anything else, Laura?
Nope.
Can I get a motion on the minutes?
I move to approve the minutes of the, what was?
April 15th.
April 15th
May 15th.
As amended.
meeting as amended.
Second?
All in favor?
Aye.
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 Minutes pass 5-1. No, 5-0, because I can count at 9 o'clock at night.
Madam Vice Chair,
Oh,
I will not be at the June meeting.
Well,
whoa.
Nice he drops that bomb on you after the election.
Nice little setup there, Bob.
If you'd like to go to my daughter's graduation in San Diego in my stead,
yes, please.
you
Oh,
may
I'm
not.
not.
You may not.
I was going to say, because
You may not.
I'm down for that.
Can I?
All right.
As my last job as chair, can I get a motion, because it's 9:15?
Motion to adjourn.
Second?
All in favor?
Aye.
Aye.
Meeting adjourned.
Thank you for tuning in to Exeter TV. Exeter TV is the town's public and government access channels, available on Comcast Channels 6 and 22. Channel 6 is your channel. If you have an idea for a program, want to host your own talk show, or submit a film, we're here to get your content on television. On Channel 22, we bring you live and replay coverage of government meetings and other town updates. A third channel, Blue Hawk Media, is operated by SAU 16 and can be found on Channel 8, with all your school sports, events, and meetings. You can watch Exeter TV online at exeternh.tv, Apple TV, and on Roku. Find us on social media for extra content. Subscribe to our YouTube channel and hit the bell to get notified about live streams and new content. Tune in to our platforms every other Friday to watch the Exeter Biweekly Report, with recaps of recent events, updates from town departments, and messages from nonprofits in your area. If you head to our website, exeternh.tv, we invite you to sign up to our newsletter to receive monthly updates about new content, upcoming meetings, and more. We'd like to thank you for taking the time to watch Exeter TV and hope that you tune in to our other content as well.